So the United States Supreme Court weighed in on the question of sensitive places in the Second Amendment. Sensitive places basically means that this is where the government is allowed to ban firearms. You may not like it. I'm not asking you to like it, but this is what the Supreme Court has said in the past. Your government, state, county, city, check your local listings, and of course the feds can ban firearms in so-called sensitive locations. Okay, if we're stuck with that, then what's a sensitive location? Well, the Supreme Court just did something and you're not going to like it. So guys, let's get into it. So really quickly, the way that the Supreme Court works is that it only has the bandwidth to take about between 1 to maybe 3% in any given year of the amount of cases that are trying to get into it. They just don't have the bandwidth to hear every single matter, which means that oftentimes the federal circuit courts, which usually hears multiple states, right? They all have kind of zone defense around the country. These federal circuit courts, they tend to be final because there's only about a 1 to 2 to maybe 3% chance that the Supreme Court is going to even hear the case to then maybe overturn them. So these federal circuit courts are really important. Something else I want to make sure that you understand is just because the Supreme Court may decline to hear something doesn't necessarily mean at all that they agree with what that court did. It doesn't necessarily mean that. Now it might, it certainly has that appearance if we're being honest, but it doesn't by any stretch necessarily mean that. I'm gonna go through some reasons to how and why that can be true later on. But for right now, let me bring you up to speed. The United States Supreme Court recently in April 2026 released its weekly orders list. This is when the Supreme Court says, yep, we're going to hear this case. No, we're not going to hear that case. When that happens, they say cert denied. So the writ for certiorari is what you got to file if you want the Supreme Court to hear your case. So when they say cert denied, that's code for not today, Sonny. The case that I'm talking about is Schoenthal versus Raoul. The question is whether Illinois could ban concealed carry on public transportation statewide, and whether the Chicago Transit Authority could ban carry on its buses, trains, and other property. That's a huge, prolific expansion of sensitive places for two reasons. And this is why you should care, even if you don't take public transportation and even if you don't live in Chicago or Illinois. I rarely take public transportation, and I assure you, I do not live in Chicago or Illinois, but I deeply care about it. Number one, there's an enormous amount of Americans who do depend on public transportation. So there's maybe, if you want to call it an altruism factor of I want people who I've never even met to be able to lawfully express their God-given right to protect themselves. Great. If that doesn't do it for you, if you don't care about that, if you're like, look, I just care about whether or not I can carry my Glock 17 on my hip, wherever it is I am. Okay, I hear you. Let me put it to you like this then. Other people who never carry firearms because they lawfully can't because of rules and laws like this, these people vote. You want as many of them carrying and knowing people who carry as possible, because the more that happens, the more invested and pro-Second Amendment, I promise you, they will become. That's the sinister nature of these laws. It's not only just stripping certain people of their God-given right to protect themselves and their family members, it's not only all too often, of course, targeting the poorest and most vulnerable folks, because again, generally speaking, if you're taking public transportation, I bet that if we just took a nationwide survey, hey, people who can't afford cars tend to be more likely to take buses, trains. I realize there's cities where this isn't necessarily the case, but you get my point. This is the sinister nature though. By conditioning how folks think about things, by just removing it from their lives, removing their exposure to it, and that way they can just define the Second Amendment, firearms, the people who carry them, and frame up everything as us versus them. That's what we're trying to get away from, folks. So that's level one. Here's the deeper level two. If the government is going to be able to classify potentially every piece of county transportation property as being a sensitive location, every bus, every whatever, the reasoning that allows that to stand, oh boy, does that travel to Lord knows everything. If you're able to kick the door down on, yeah, we should be able to ban public transportation carry. Why? Well, because there's lots of people there. Okay, so does that mean that now we can ban concealed carry, open carry, any kind of carry, any place where there's lots of people? What about, well, it's a place that the government owns or maintains or upkeeps? Great. Does that mean like one particular state, you can now ban transporting or carrying any kind of firearm on any public road or highway? Folks, this has been tried. This is not hyperbole. There have been anti-gun states that have tried to ban the carry of firearms on any public road because they have declared that all public roads and thoroughfares are all sensitive locations. So you see the deeper threat level of what's going on here. It's not the symptom. The symptom is public transportation carry. The disease is the reasoning and rationale and logic that drives that symptom being okay. Hey, please excuse this brief interruption to bring you a word from our sponsor, me, or more specifically, my law firm. You see, what you may not know about me is I'm not only an ex-prosecutor, criminal defense attorney, but I employ a few dozen attorneys all over the great state of Wisconsin. My firm handles criminal defense, traffic law, divorce, family law, as well as estate planning all across the dairy state. We've got different wings of different attorneys doing different things, so you don't have to have some sort of just generalist handling your case should you decide to come in. So what's the ask? Well, look, if you've been with me for my journey of at this point about 10 years and counting, not all of them on my own YouTube channel, but about 10 years and counting of putting out free legal education content that's out there, first off, thank you for joining me and thanks for watching this video. And if all you can do is just keep watching, hitting the like button, sharing it around, commenting, thank you. And I really do mean that. However, if you want to take it one step further, please consider following the directions below, both in the description box as well as in a pinned comment down in the comment discussion field about how you can leave a 5-star review. So again, if you can do that, I tremendously appreciate it. Not only myself, but everyone else want to thank you for doing that too, because it helps us bring our mission across Wisconsin. Don't forget to stick around to the end of the video for our ever popular quote of the day. Now back to the show. So the 7th Circuit Court of Appeals, that's what we're talking about. This is generally an anti-gun Circuit Court of Appeals. There's a lot of anti-gun decisions that have come out of it. 7th Circuit Court of Appeals basically covers a lot of states in the northern Midwest, including my home state here of Wisconsin. The Supreme Court just decided they're not going to touch this case. They're not going to undo the anti-gun reasoning. That means, for now, the Illinois transit carry ban stands. Check your local listings if you're in Illinois to see exactly what that means. I'm not going to get into all the nuances of that. The 7th Circuit's rationale stands. That's that underground disease that just spreads like rats' nests. And every other federal appellate court that is sympathetic to gun control potentially just got a green light to now cite this case and this logic and rationale as being fine because, hey, the Supreme Court turned down hearing it, so maybe that's good. So I want to quickly and briefly in English walk you through what the 7th Circuit Court actually said, because this is where it somehow can get worse. So we've got the Brune 2022 decision. This was part of the Holy Trinity, as I like to call it, of United States Supreme Court decisions that really set the bar, the standard, the tempo of protecting the Second Amendment and gave courts teeth to punch holes in anti-gun law and striking them down as being unconstitutional. So in that Brune case, the Supreme Court said that the government restrictions on the right to carry, they must be consistent with the nation's historical tradition of firearm regulation. If they're not unconstitutional, they can be struck down. The court also acknowledged that there's a narrow category that I already mentioned called sensitive places where carry can be limited. Historical examples would be polling places, courthouses when a court is in session, legislative assemblies when those are in session, schools, narrow, specific. The 7th Circuit took that narrow category and stretched it, like Gumby, if you're old enough or young enough to know what I'm talking about, to essentially, as I mentioned, any crowded space where vulnerable people might be present. That is not a historical rule. That is a modern day policy preference dressed up as being constitutional, because we're going to put constitutional sounding words in front of it. As the plaintiffs pointed out in their final brief to the United States Supreme Court, and I'm quoting, "Every population is vulnerable where the threat is gunfire. What makes children uniquely vulnerable is that they cannot bear arms for their own protection. Disarming law-abiding adults only makes the rest of the population more vulnerable by depriving them of the presence of armed citizens to deter armed criminal attack." We're talking about law enforcement. We're talking about the fact that if you look at mass shootings, Nearly half of mass shootings are stopped by lawfully armed private citizens. It's over half if you exclude the fact of looking at gun-free zones. So if you take all the mass shootings that only take place in gun-free zones, which by the way is about 90% of the time, give or take. The anti-gun number is 88%. The pro-gun number is about 95%. I don't care. You can take either one of them. If we take out those and only look at the mass public shootings that took place outside of gun-free zones, over half of them are not stopped by law enforcement. They're stopped with a normal man or woman who is lawfully and responsibly carrying a firearm. But I understand that, hey, and when you have a bastion of just public safety, maybe we just don't want any firearms going into it. Because we all know, I'm sure, that public transport in Chicago, the Chicago Transit Authority, I think it's called, the CTA, I'm sure nothing bad has ever happened on a Chicago bus, metro. No robberies, no stabbings, no shootings, no violent assaults, right? Yeah, not so much, right? What anti-gunners just seem, it's such a smooth-brained position. I don't know what to tell you. They don't understand that when you pass laws prohibiting people from, defending themselves, that it not only gets much more difficult to defend yourselves, but then, the next order effect is, this is just a victim-only zone here. There's no one here to defend anyone. I'm a bad guy. I'm just going to go in there, and I know I'm going to be the only person armed. Fantastic. So folks, I could keep deep diving what happened with the court, but you kind of get the gist to it. I think it's worth pointing out that since the Brune decision 2022, state governments in Illinois, New York, New Jersey, California, Hawaii, Maryland, and I want to say Massachusetts, and I feel like Rhode Island should be on that list, but I also don't want to be wrong. I'm sure someone will fact check me either way. Was Rhode Island on this list of states that really did their hardest to expand sensitive place, sensitive carry ban laws? And I get it. The theory of these anti-gun states is, well, if we can't restrict who can carry, thanks to the United States Supreme Court, we can at least restrict where they can carry. Like the time that New York State said that the entire island of Manhattan, that's all a sensitive place. I mentioned that it's not necessarily the end of the world if the Supreme Court doesn't take something. Ideally, let's be clear, I don't want to mince words, I absolutely want them to take it and strike it down. There is a world where that happens. Unfortunately, we are not in that world right now. Okay, so what is the next best world we could be in? The next best world is, there's some judges who I'm sure would absolutely want to do that, but there weren't enough of them. It wasn't a majority. Okay, there's a few fence sitters out there who maybe are on our side, but they want to see lower courts flesh things out and beat them up more. This is something you do see from appellate courts out there, including the United States Supreme Court, where if there's an issue that's kind of percolating around the country, they may decide it's not ripe enough. We're not ripe enough to kind of pick that fruit because they want to see what other courts do in tackling these questions, developing the facts and exploring the law before they can step back and say, all right, mom and dad's home. Let's take a look at this and let's see what we need to do here, because now we can see a whole bunch more arguments and a whole bunch more fact patterns arise, and we're going to be in a better position to make the lasting ruling. That's the next best world. It's the one I suspect and I hope that we live in, but that's the next best world. And obviously, it gets all the way from there to, we are not going to like the outcome, the final outcome, should this ever get to the United States Supreme Court. That's the worst timeline. I don't think we're there. I think we're somewhere between there and that second best one. What do you think? What do you think is going to come from this? What do you think is going to happen as a result of all this? I want to remind you again, voting matters, because all of these judges in all of these federal circuit appellate courts, these are lifetime appointed positions appointed by the president and confirmed by the United States Senate. So if you don't like this, you've got your friend who doesn't vote to blame for it. Just keep that in mind. Let me know in the comment section below what you think about all of this. We're going to close out with the ever popular quote of the day. Before we do, don't forget to hit that like button, share the video around. I appreciate you for sticking around. We're going to close out with our ever popular quote of the day. This one comes from Thomas Jefferson, a draft for the Virginia State Constitution back in 1776. Quote, "The right of the people to keep and bear arms shall not be infringed. The people have a right to keep and bear arms for the defense of themselves and of the state." It would have been great if that was the version we got in the final copy, right, of the United States Constitution some 12 years later. It's always great to see the insight, though, of exactly what they were thinking, because these were the same people. I appreciate you sticking around. I'll see you in the next one. Take care. Thanks for joining us on that video, and if you liked that one, then I think you're gonna like these over here too.